Good morning, Your Honors. May it please the Court. I'm Marla Zink on behalf of Jennifer Mothershead, and I'll watch the clock to try to reserve 3 minutes for rebuttal, please. Thank you. The state court record here alone is sufficient to show that Mothershead was prejudiced by her trial attorney's failure to hire an expert toxicologist in a scientific-heavy case. The initial opinion that trial counsel had was a conclusive rebuke to the core of the state's case against Mothershead. And failing to put this on at trial caused at least a reasonable probability that at least one juror would have found reasonable doubt in favor of the reasonable doubt in the state's case. This opinion was based on Dr. Ployce's collective review of all the case data, and scientific and medical, and he concluded that it showed that the state's evidence does not support its case.
Well, he didn't conclude that is the problem. He said, that's probably the case, but I have to do more research.
Well, he said, subject to more research, subject to additional work, which was based on the same records that he had already reviewed. So like any expert, they're going to provide an initial opinion to counsel, and then if retained further, they will double-check their work and put together a report. Dr. Ployce had already reviewed all the records relevant to this case. We know from the state court record that he had reviewed both data from both laboratories, all the medical records, diagnoses, objective observations, all the court documents, and all the witness statements. He'd also conducted independent research. He'd compared and contrasted the case data with data in the toxicological literature, and he'd considered alternative scenarios, including the one that the state put forth, that Mothershead adulterated the eye drops. Dr. Ployce also had exceptional qualifications that are noted in the state court record that anchor this opinion. He had relevant degrees.
Is your argument that the state Supreme Court's decisions and state court of appeals decisions were unreasonable findings of fact, or what?
Partially correct, Your Honor. Our argument is that the Washington Supreme Court's decision was an unreasonable application of the law and the facts, an unreasonable determination of the facts. Of course, to reach prejudice, the court does have to find that. And we look only at one decision. A prior panel of this court found that the Washington Supreme Court decision was a well-reasoned merits determination. And so looking to that decision, we know that it's unreasonable.
The decision was actually a decision about why it wasn't going to take the case on a plenary basis. So it's sort of a strange, Washington has this system as I understand it, but it's sort of a merits decision of sorts, but it's not exactly a merits decision. I understand it was held to be a merits decision, but it doesn't say very much.
Well, and that's part of why it's unreasonable. It needed to say more about Dr. Ployce's opinion.
Well,
about the weaknesses.
What it was really doing was saying that because of the character of what it was really saying that the state court of appeals opinion was correct and it should be read as incorporating it, the state court of appeals opinion, it seems to me.
Well,
which was more expansive.
That would be disagreeing with the prior panel of this court, which found the Washington Supreme Court decision.
No, it said it was a merits decision, but it didn't say that it was a merits decision standing on its own and without regard to the state court of appeals decision.
Well, it did say that it was the last reasoned decision of a state court, but even if you look at the court of appeals decision, they didn't do what's required from Hinton, from Terry Williams versus Taylor, or from Porter versus McCullum, which is to look at both the weight of the evidence that was missed to be presented and then weigh that against what was actually presented in state court. And we know from Porter versus...
Address the issue that we asked you to address.
The Rhines stay? Sure. Should the court find that there isn't sufficient grounds on the merits here, just like in Dorr versus Shin, this court has already found that Washington has escape hatches that allow for a state court to accept a second successive and untimely PRP. So we would ask that the court apply a Rhine stay if it's not going to decide the case on the merits.
Have you moved for a Rhine stay?
I'm sorry, excuse me?
Has there been a motion for a Rhine stay?
There hasn't been a motion for a Rhine stay, but the court considered this a motion for a Rhine stay. It's not clear that a Rhine stay can be forfeited. Stays are part of the court's inherent equitable authorities and can be entered sua sponte. And in primary jurisdiction cases, courts are required to consider stays. That all suggests that a stay is not a claim that can be forfeited. But even if it can be forfeited, the court has discretionary authority to waive forfeiture and can also find that this is part of the original claim that was presented, and therefore forfeiture doesn't apply.
Can we grant a stay that hasn't been moved for?
Well, again, this court could consider this current argument a motion for a stay or provide leave for additional briefing on that issue. The discretion of this court to enter stays despite forfeiture or where it might otherwise find forfeiture is in the interest of justice and essentially where there's been a miscarriage of justice. And here we have a system that the court talked about in Correll versus Stewart, where the state courts, where the Washington state has prevented Mothershead from raising an ineffective assistance of counsel claim in direct appeal. And then the state came in and opposed any opportunity for Mothershead to develop the record in state court. We moved to federal court, and the same state is arguing that the record is insufficient. The decision in the state court was on the merits, and we have a situation where Mothershead's never been allowed to present a claim of ineffective assistance of trial counsel. And that claim is substantial here. Just like in Kennedy versus Adams from this court, the court can find on the state court record alone that trial counsel was ineffective and that it prejudiced Mothershead. But the court can also find that Mothershead was diligent and look at the full record in federal court. The standard for diligence has not changed since Michael Williams. That was reaffirmed in Shin. This case is similar to West versus Ryan, where based on trial counsel's performance, the court found that the counsel had been diligent, even if not successful, and even though they had missed evidence that was later presented in federal court. This case is similar here. Mothershead and her attorney acted diligently by presenting the claim, by supporting it, by asking for an evidentiary hearing. And so the court could then look at the full federal court record. I'll reserve the remainder. Thank you.
May it please the court. My name is Holger Sonntag, here to represent the state of Washington. This court should affirm the district court because the district court correctly applied AEDPA deference because, as this court concluded in a prior interlocutory decision, the Washington Supreme Court did a merits decision, and that merits decision is a reasonable one, both factually and legally. But even if this court were to review this case de novo, even with the additional evidence that was presented in the federal court, this court should find that there's no prejudice because Dr. Ploys conceded that bleach could have been added to the contaminated eye drops, and his speculations about alternative causes.
Where did he concede that?
What's that?
Where did he concede that?
He conceded it in his, I believe, in his first declaration that he submitted in the federal court. And so that is, let me find
What is the page number that you're referring to?
The page number is 13 ER 3450. He said there that he understands and agrees that bleach could have been added, but then he added some qualifications about documentation and similar things. But obviously, that would be a concession that the prosecution would have seized on if Dr. Ploys had testified according to his declarations.
Well, it seems to me, I guess I just read it somewhat differently, that this had, that there was not enough done to exclude other possibilities, that in other words, that the scientific evidence was insufficient. So I don't read that as a concession exactly.
Well, I mean, he does say that he understands and agrees that bleach could have been added. But regardless of whether he conceded or not, this court doesn't even have to review the evidence that was developed in the federal court because, as I said, the determination of the state courts was reasonable both factually and legally, and so we don't even get to that new evidence that was submitted in the state court. And
I guess I'm not really sure I understand that. Are you saying that there could be no prejudice?
well, there was no prejudice found by the state courts, as this court knows, and based on simply on the state court record. So simply the one sentence initial opinion that was submitted with the PRP that Ms. Mothershead submitted and that even counsel resubmitted. Based on that one sentence statements, there is simply no reasonable probability that the outcome of the trial would have been different, because that one sentence statement is not supported by any factual discussion. It's not going into any of the facts that Dr. Ploys later evaluates and elaborates on in the federal courts, but that obviously was not before the state courts. And Ms. Mothershead had every opportunity to develop that record in state court, both
Well,
per
he
se.
tried to. He asked for an evidentiary hearing.
She sure did, but the court also appointed counsel
Right.
to her specifically, that is by assumption, to develop the record further, because the court obviously saw, look, an expert had been retained in before the trial, the expert had reviewed the record and so forth, but then there was no final.
You get to review the reasonableness of the state's decision not to hold an evidentiary hearing. In other words, they did have this document, and it had preliminary findings. They regarded that as, under their rules, as inadequate.
Right. Because she had not even raised
That for reasonableness?
she had, under the Washington rules, she had to make a prima facie case under Strickland, and she had not done that. And so therefore she was not entitled to an evidentiary hearing.
And we don't get to review the question of whether she did make out a prima facie case?
That is a state court and state law determination. And so I would think.
Isn't that an enormous hole with regard to the application of the federal rules with regard to when you're entitled to, when you have adequate diligence that you are entitled to a hearing?
Your Honor, the rule in Washington is that evidentiary hearings are not discovery devices. Evidentiary hearings are there to resolve controversial and controverted issues of fact. And so it's basically the same rule that we have in the federal court. And under the Washington case law that the Washington Supreme Court and the Washington Court of Appeals applied, she had not made a prima facie case because she had not submitted a final and ultimate opinion from Dr. Ploys.
Counsel, so that is the crux of the problem here, right, is that the state had a somewhat equivocal and brief statement from plaintiff's expert, but now in federal court we have a much more complete analysis from that same expert.
Sure.
And so we're looking at two different evidentiary records, which brings me to the focus order question. Can you please address that?
Yeah, so a stay under Rhines is not available in this case because we do not have an unexhausted claim. All claims before this court, certainly the ineffective assistance claim that we're talking about regarding Dr. Ploys, is exhausted. It has been adjudicated on the merits, and therefore there is nothing this court could stay. If this court Ms. Mothershead would have to raise a new claim.
But we do have case law that says that at some point, when you have enough new evidence, it's a new claim. I think Dietrich says that, but I know there's case law that says that.
Yes, but you also have case law that says that after the Shinvia Ramirez case, that new evidence, even for that limited question, has to be reviewed under 2254E2. In other words, there we come back to the diligence inquiry, and here in this case, we would argue that there was no diligence, potentially by Ms. Mothershead, but certainly not by appointed counsel. I mean, Ms. Mothershead was arguing.
I don't understand how that point
Well, there is.
And, excuse me, interacts with the question of whether this is a new claim or the same claim.
There is case law in this circuit that if the claim is fundamentally altered,
Right.
that
It's a new claim.
it's a new claim, and it's
have to do with Shin versus Ramirez.
because this court said in McLaughlin v. Oliver, that's 95 Federal Reporter 4th, 1239, page 1250, that the Shin v. Ramirez rule also applies to this question. And so therefore, we would first have to determine whether there is diligence of Ms. Mothershead in developing
Would
that
it
case.
make sense for us to have supplemental briefing on the Rhines question? Because you're now bringing up cases that
Yeah,
haven't
sure.
been discussed before. And so
Yeah, I mean, that would be our preference if we could brief this question, because then we would no longer kind of think in hypotheticals, what could the claim be, what is the claim? Then we would have to, the opportunity to actually address those cases that, in fact, just last month, I believe, in Reinhardt v. Thornell, this court again affirmed that under Shin v. Ramirez, 2254E2 applies even to evidence that is used to expand the claim, in other words, to determine whether there's an unexhausted claim.
that sounds totally circular. Well, I have to read the opinions, which is why you have to brief it.
Yes, very good. Unless you have any other questions, we again ask this court to simply affirm the district court and conclude that there was a merits determination and that was a reasonable merits determination. There is no unexhausted claims right now before this court, so Rhines doesn't even apply. If Ms. Mothershead were to try to create a new claim, that might run into issues with a second and successive petition, which would be time barred anyways. And that would fall under Rivers v. Guerrero, where the Supreme Court said once the district court has made a merits determination, in other words, once the judgment has been entered, no new claims can be amended into the primary petition. In other words, there has to be then a new petition, which in this case would be obviously successive, but it would also be untimely in this case. And so I believe we're stuck with the record, for better or for worse. And again, we ask this court to affirm the district court. Thank you very much.
Judge Bernstein's correct that under D2, this court can review the reasonableness of the state court decision not to hold an evidentiary hearing. And we know from Milke and Perez, and then that can be based on the constitutional standard required here based on Strickland. We've cited the cases in the briefing showing that you need to have something to weigh it against. And returning back to D1, that the state court decision was unreasonable based on clearly established law. The state court here at best acknowledged Dr. Ployce's opinion, but did not weigh it, and that is not sufficient for clearly established case law.
Well, but
we know
essentially it did. It basically said there was so much evidence, expert testimony at the trial by the prosecution that almost no matter what he said, it wouldn't have mattered.
Yeah, so if we review it liberally to say that, that's insufficient under Porter versus McCollum. And this court found similarly in Andrews versus Davis that it's not sufficient to say that there's 15 experts on the state side and therefore no one expert could outweigh that. You have to look at who the expert is and what the opinion is. The court didn't look at any of the work that Dr. Ployce had done to reach that opinion, and it didn't look at his qualifications, and it didn't weigh the opinion itself, which was a conclusive rebuke to the state's case. And if the court had done that, as this court can do and should do on de novo review, the court can find prejudice on either record.
But
I'm
are you
confused
saying
because
that
but at the state, we did not have the full opinion. I mean, saying the state court didn't look at his full opinion seems to me a little unfair when none was provided. I mean, that seems to be part of the crux of the problem here.
No, and maybe I misspoke there, but what I was saying is it didn't look at the full weight of the opinion that was provided in the state court record, which was a rebuke to the state's case in the whole on the scientific evidence.
But
so,
if he had, so are you saying that if he had gotten up and said only what was in that paragraph, that would have had any weight with the jury?
I think that's
That's
correct.
the problem.
Because,
If he had just gotten up and said that, nothing else.
well, I don't think that's how it would have come out at trial, right? It would have come out that the trial counsel
That's
would
the
have.
problem is we don't know how it would have, and based
No, I
on
think we
that
do.
document, not on the second document.
Yeah.
We don't know how it would have come out.
No, we
at
do,
trial.
because we have in that document all the work that Dr. Ployce had put into that opinion. So, and his qualifications are in the
We
state
don't
court
know
record
why
as well.
he gave absolutely no indication of why he thought anything he thought,
Right.
or even that he thought it conclusively.
Right, but if a trial attorney had put on an expert with the qualifications of Dr. Ployce, asked the doctor to explain to the jury all your qualifications and experience in this field, that you've performed over 400 toxicological assessments, that you have regularly served as an expert on both sides, that you looked at all the case data.
I think they're probably wrong, but I'm not going to tell you why. That would have been it.
I think you would say that they are wrong, that the evidence doesn't support that conclusion, and that's sufficient to create a reasonable probability of that at least one juror would just find a reasonable doubt in the state's case. In terms of Rhines, I would just point the court to Dickens versus Ryan at 740 F. 3rd 1302, which is one of the cases that in this court that says that if you place the case in a significantly different and stronger evidentiary posture than it was when the state courts decided it. Happy to provide supplemental briefing on that, and we ask that the court reverse here. Thank you.
Okay, thank you. I believe we are concluded for the day. Thank you.
All rise. Court for this session stands adjourned until tomorrow morning at 9:30 a.m. Thank you.